Okay, our next witness is Aaron Britvan. Okay.
May I take a little water, please?
Okay.
He came from Boston on the 14th, so if you move him up, that'd be good.
And do you swear or affirm that the testimony you're about to give is true?
I do.
Okay, if you could state your name and...
Well, the first thing I'd like to say under oath is this is a tough act to follow.
Yes?
Aaron Britvan, you want my address?
No.
Okay. If I may read from my statement, it may go earlier. Honorable members of the committee, I thank you for the opportunity to address the committee in relation to the bill known as Bill of Adoptee Rights. Although I chair the adoption committee of the Family Law Section, New York State Bar Association, time constraints have prevented sufficient time and review by the bar as to any position on this bill. However, I've been authorized to give testimony as an individual. The salient portions of the present bill address the right of adoptees in New York State, 18 years or older, to obtain an appropriate copy of his or her original birth certificate and or the information appearing on such certificate. In addition, the bill also supports the rights of adoptees to obtain a litany of specific information relating to the birth parent of his or her heredity, inclusive but not limited to the religion, occupation, nationality, and ethnic background of the birth parents at the time of the adoptee's birth. In addition, the bill provides for a contact preference to be completed at the option of the birth parent and the indicating as set forth on page 3 of the bill, lines 17 through 47. However, for further clarity, there is an open question as to whether a no contact preference will permit issuance of a birth certificate or whether a birth certificate can be issued with identification information redacted. I'll just say that for clarity's sake. Further, is the proposed bill and its provisions retroactive, and if so, what are the rights of the adoptee when their birth took place at a time prior to the ultimate effective date of the law? I come before you as an individual attorney involved in adoption law for over 30 years and having been involved in many, many adoptions. More important, I come to you also as an adoptive father of an adult adoptee who came into our life at the age of 3 days. I am proud that my oldest daughter, Lauren, is also an attorney who has been admitted to the bar of New York State. After the birth of Lauren, we were blessed with 2 biological daughters, Dina and Nicole, and accordingly have performed the proverbial hat trick. In my practice, which has existed for many years, I have come to realize that the courts and the legislature in New York State have always sought to balance and protect the respective rights of the adoptive triad, made up of the birth parents, the adoptive parents, and most of all the adoptee, whose best interests we are all hoping to serve. In the first instance, may I state that I have no issue with the concept of the adoptee's right to obtain all information relating to the birth parents, inclusive of the information, here to mention, relating to religion, occupation, age of the parents, ethnic background, and the like. Supposedly, such information can be obtained and ultimately stored with the Adoption Information Registry, as set forth in Section 4138C of the Public Health Law. Under the circumstances, the adoptee may only obtain from said agency non-identifying information subject to the direction of the birth parent as indicated on the contact preference form. However, I find nothing in the proposed bill which directs a birth parent or adoptee as to even the existence and availability of registration with the registry. I believe that the lack of direction as to the ability to obtain information is unknown to most individuals, including the adoptees and their birth parents. To overcome this, I suggest that the contact preference form should be presented to birth parents upon their execution of a surrender to an agency or at the time of the execution of a consent in private adoption. The form should also indicate, for information's sake, how contact may be made by the registry at any time. I think that the registry has not worked well because no one knows how to get there. The signatory should be advised in writing that preferences theretofore may be modified by the birth parents, that any preference is open to modification by the birth parents at any time thereafter, and possibly indicate the right of the adoptee to receipt of a copy of the original birth certificate any time upon reaching the age of 18. It should further indicate that the birth parents can provide additional medical information thereafter to the registry. I also suggest that the preference form and the surrender or consent form, that there be information indicating the existence of the registry, as I indicated earlier, and that such other departments which can provide information as to modifying, change, or preference, and or the right to provide additional medical information. Such information should be provided to the birth parent, together with the adoption consent or the surrender of the child to an agency. I make reference now to Section 115B of the Domestic Relations Law. A copy of the bill is set forth in my statement. And the point here is that a contact preference and information about the registry in this bill, which is only about 4 years old, indicates that it's done at the time a consent is signed and the birth parent or parents are given information that they can make contact in the future or change their preference. I respectfully suggest that the sponsor of the present bill review and determine, even if there's any benefit to seek an amendment to 115B, subdivision 9, so as to modify same to indicate the ability of the adoptee to obtain a copy of the original birth certificate at the age of 18 or later. Finally, it is important that we deal with medical history and the contact preference. Particular reference is made to that portion of the bill indicated on page 5, lines 40 through 56. It should be noted that what was formerly known as guardian ad litem is now known as attorney for the child. So that should be automatically corrected. I certainly recognize the importance of obtaining medical health information, but reference is made on line 42 of the duty of a law guardian, which should be attorney for the child, to obtain comprehensive completion of medical information, this is the important thing, prior to acceptance of the termination of parental rights or the entry of a certificate of adoption, which means that can be held up if it appears that not sufficient medical information has been obtained. Based upon my experience, it should be noted that in the normal proceeding for adoption, there is no appointment for a guardian ad litem or an attorney for the child. It is more common that an attorney for the child will be appointed on issues of custody, revocation of consent, or any contested court proceeding wherein a child and his or her best interest are involved. At this juncture, I have the following concerns in reading this portion of the bill, where it is stated that to ensure the comprehensive completion and filing of medical information, and that's supposedly by the attorney for the child, that same be completed prior to the acceptance of a termination of the birth parent or the parental rights or the entry of a certificate of adoption, which means I don't know how it is calculated where even if you could have a guardian ad litem, how does he or she ensure that this is all the information there is? And if they don't have it, in the sense, know that this is all that we have, and they want further search, it can hold up an adoption and technically hold up the termination of the parental rights, and it doesn't work that way. It would be in direct conflict with the best interest of the child if an adoption is not finalized, or if a birth parent can't give a statement or terminate voluntarily, her rights, where they can no longer be contested. Normally, the termination of parental rights in a private adoption, normal private adoption, occurs by operation of law. And under the law, a birth parent has 45 days from the signing of the consent to notify the court if there's any desire to revoke that consent. If nothing is done within the 45 days without going to court or anything else, there's an automatic termination of the right as of the 46th day. No steps have to be taken as long as the birth parent has not revoked within 45 days. So there's some conflict. I'm just bringing it up in the nature of the bill by saying that there can't be any finalization or there can't be any termination. There is a termination. Statutorily, a adoption ostensibly cannot be finalized in less than 3 months. But normally the way things are today, it usually takes 3 to 6 to 7 months to finalize it based upon court proceedings, backlog, and what have you. But to say that you cannot finalize an adoption until all medical is obtained would damage that portion of the bill. Although obtaining medical information of the adoptee or birth parent certainly serves the child's best interest, there is no question that the delay of finalization under these circumstances will conflict with and severely counter the best interest of the child. Procedurally, it should be noted the private adoption of termination, and I already discussed 45 days. My final question is, well, I'd like to make a statement again. There's no automatic appointment of a guardian ad litem. It's directing a guardian ad litem or attorney to obtain the medical information. That is not, there is none. There's no appointment. The proceeding just goes. Only if there's a contest on the proceeding will a guardian be appointed. So the way it is written, nothing can happen. So I think there has to be clarity there. Final thing is, if there is an attorney for the child, guardian ad litem, as the judge may seem fit, who is financially responsible for the payment to the guardian ad litem? Is it that they make a stipend from the court, in which event it might create a situation where there are financial implications to the bill? Or is it paid by the adoptive parents, which adds to their cost of the adoption? Understand also there is no conflict between the adoptive parents and the child in getting medical information. And obviously I'm talking about the adoption of a young infant, newborn, whatever the case would be. And it is important for them to have it because they're going to be bringing up the child. They are the parents. It's their responsibility to maintain the child in good health and what have you, and therefore getting as much information as possible is important. It is also important, as indicated that now exists, that the birth parent know that at any time that they find additional information about their health, they can either confidentially or otherwise submit that to the registry. But very important is let them know how to make contact with the registry. That is my statement.
Thank you. Before we go to questions, it would be very helpful if you could email, attach your testimony to an email to us so we can have the full written statement.
It should already be here because I spoke to one of the aides and it was already emailed.
Oh, okay,
It
fine.
was an email to Assemblyperson Webber.
We have it. Yeah, I gave it to Liz.
Oh, okay, all right, thank you. Well, we don't need that now. I just wanted to make sure we have it for the future. Mr. Borelli?
Mr. Britvan, let me just start out by saying thank you for being an adoptive parent. Adoption is a great thing, and without adoptive parents, it wouldn't happen. You mentioned that you believe that adoptees should be given access to information that you deem pertinent, medical, ethnicity. That's correct, right?
Yes.
So I was given that. I'm an adoptee, and I was given that. And at 16 years old, my parents let me see that. And I found out that I was half Italian and half Irish, and I was happy. So, identifying with an ethnicity, I was happy. They're wonderful people. Ethnicity is important to an adoptee as it is to a person who's born and resides with their birth parents. But then, a couple of years later, thanks to DNA, I found out that I was not Irish, that the paperwork that I was given and lived my whole life believing was incorrect. Because the paper relied on a 16-year-old woman who was scared to identify the ethnicity of a man she may have only met once. Maybe he had blue eyes and blue hair. He was probably chubby and probably had thinning hair. But and then that same document goes on to provide medical history. How can we verify that that medical history, taken at one moment in time, when this woman is 16 years old, it negates everything that's happened to her or the father after that moment in time? For me, it's 32 years. So why is it okay to be missing or potentially not have correct information and, at the very least, not have a continual medical record going through the person's life?
Well, you have to understand that in the practice, getting medical records is not really, just a matter of asking the birth mother something. How do you feel? You got a headache, anything? We get medical records from the treating physicians. And if they can be filed, with the registry, that's fine.
Is that for the mother or for the maternal grandmother, the paternal grandmother, all that?
No, it's only for the birth parent.
So then we don't know the genetic history of things, genetic issues that may skip generations.
I've always agreed with you when I speak to my clients and tell them we ask them to identify, their background. In other words, is there any cancer in your family, etc. We can only rely upon the information given by the birth parent. There's no way we can't call in relatives to examine them or what have you. When you adopt, and I don't mean to, to be flowery with this thing, the interesting thing is that the love of the child, the bonding with the child is immediate. And as I said, the adopting parents are very concerned about the health and what they can do or what they should know in caring for the child.
I agree with you 100%, and I was fortunate. I was adopted by a wonderful family, and I know even some of the things I say on this issue is difficult for them, and it's obviously, and as everyone perhaps in this room knows, it's a tough issue for me to deal with. But, my parents and I still don't have the answer to the question I've asked. How do we know the information is correct, and then how do we know what happened to the birth mother or the maternal grandmother and so on and so forth after the birth of the child?
There is no provision for that in the law, and I think it would be impossible to obtain.
Correct. I agree with you now, and hopefully we're going to change that. But wouldn't this bill then give people an avenue to explore? I mean, it's not a concern for you, right? It's not a concern for you as an adoptive parent. Yeah, I think if you wear your hat as the adoptive parent, it would be a concern. But as an adoptee, I'm concerned I may develop some type of genetic disease if I want to. If I have symptoms, why is it so wrong that I seek out medical history or recent medical history from my genetic ancestors?
If you find the birth parent and they can tell you the information, that's fine. We are suggesting that if the birth parent learns anything new about their genetic background, hopefully they can and hopefully they will file that with the registry. But you can't make people do it. There's nothing illegal by withholding information. We all want to serve the best interest of the child. In what capacity? You know, there are birth mothers there, very honorable. They want what's best for the child. But we're also, in light of what you're saying, we're moving towards open adoption. And if you can have open adoption, you can get a birth certificate anyway. And that's, I think, important. Today they have what they call PACA agreements, where there are post-adoption agreements between the birth mother and the adopting family as to contact, as to photographs, as to staying into contact with each other. Adoption over the past 10, 15, 20 years has been changing, and it is changed. And knowing as much as you can about the child's health and by its, you know, background of grandparents or whatever is important, could be important, what have you. In my case, my daughter came and was adopted in Pennsylvania. She was 3 days old. We got no information. We did get a copy of her original birth certificate. That was made available to her at any time after we got it. It wasn't that we were going to say, let her be 13 or 14 or 15 and we'll come back from temple or church and we'll discuss it. My daughter was advised of her adoption before she could understand the word adoption. And anything she needed, because if it was for her interest, I would do. I would, you know, do anything to help her. There were times when I asked her, do you want to do the search? Are you ready? Do you have any feeling of need? And this only applies to her. Her answer was, you know, I'm curious, but I have no real need to do any searches. But that can change also, like the testimony of the prior witness. Things change. And anything you can do, as, you know, maybe contrary to what the judge said, this is what the position is today, confidentiality. Change that, all right? You might almost say, then we don't need a preference. Forget the preference. If we're not going to honor it anyway, why put preferences in? And then you wonder, why is there a preference if you're not going to follow it? So I like the concept of the bill. I think it needs some modification.
Thank you. We'll look at your written comments.
So let me just, in the interest of full disclosure, mention, Mr. Britvan, that you and I have worked together on some bills that have become law that have brought the adoption process more into the 21st century, and for that, I and all of us are appreciative. And when you speak of health, the health of the adopted child, we're not simply speaking, are we, about the physical health? We're speaking about the emotional and the mental health as well, are we not?
We're talking about everything we can find out.
And that further emphasizes what Ellen Kelly Moore described as her having a small hole in the heart because she wasn't able, it was so difficult to find out her background. Correct?
That's correct.
All right. So, and let me just finally state to my colleague that I don't know how, there's an inherent sense of questionable reliability in what adopted birth mothers say, but that same inherent sense of questionable credibility applies whether we're adopted or not. And I just want to mention to you that I grew up thinking I was simply Eastern European Jew, but my brother had his DNA tested, and it turns out it's not just Eastern European Jew. We didn't know. There's Spanish, Greek, Italian, Northern Russian, and for goodness sake, Finnish DNA traits. So we're all kind of in that same boat to one extent or another, although I do appreciate the intense interest that adopted children would have and would rightly have in knowing the truth. But we don't always know the truth, even if we're not adopted. Thanks, Mr. Britvan.
Thank you.
Thank you.
Thank you very much.
The Gallic tribes and others wandered all over Europe. Which is why there are fair-skinned, red-haired people in Turkey and Spain and Ireland and the Ukraine, some of whom are my ancestors.